private agreements are going to be recorded. So, I said that one of the most important purposes of this new law is to provide legal certainty, because it's what most of us, or all of us, are actually looking for. We want to be able to tell our clients that in Mexico we have legal certainty. It happened many times that you went to the public registry before closing and you checked and double checked and triple checked and everything was exactly the same, and then everything appeared that the property was actually John Walsh's, and when the transaction finally closed, guess what? It was no longer John Walsh. So that created a lot of uncertainties, okay? And most likely that happened because there was a private agreement in place that was not recorded in the public registry, so there was no way for any of you to know, except by the parties that signed it, that there was a purchase in place. With these changes, we're going to be able now to record a private agreement, the assignment of rights or purchases, and yet it's not way too clear. It has lots of big ifs, because it's new. Do you remember when the anti-money laundering came in place? It brought any sort of questions and big ifs, and this law is not different. So let me go to the specific articles that I want you to know.
Is there any possibility that this is going to help the people that had problems before the law? That would be great.
It will help as long as some criteria is met.
Wow, that's awesome.
I mean, guys, this is not meant to avoid going to a notary public. It wouldn't have happened. Okay? It is meant to create certainty meanwhile a transaction reaches a notary public. If this law was in place when Bella Sirena or when other, fiasco had taken place, it wouldn't have happened.
Is this law going to help them also? That's what I'm asking.
Again, if some criteria is met, and I'm going to go through that. Article 150 of the law says, only can be recorded, and then a title, Number 3, exceptionally, private documents that in such way were authentic and valid, according to the law, provided there's a note on those contracts with a certification from the notary, registrar. I don't know the translation for corredor público, but it's like a cousin of the notary. Okay? The municipal authority or the judge, they have to verify that the signatures and the content of the contract, the signatures of the party and the content of the contract have been ratified before any of those authorities. Then it will be exceptionally accepted for registry. So for all those contracts in the past, that have not been ratified won't be accepted. If you take a contract 5, 7, 10 years ago to a notary and they ratified it, both seller and buyer, then that document may be recorded.
Ricardo,
See,
what is the name of the law? Can you, the actual name of the law?
it's called Ley Catastral y Registral del Estado de Sonora.
So it's not actually a new law. It's
It is a new law, but it kept the same name.
Okay.
But it's actually abrogating or canceling
The previous one.
order.
So everything. All the
Because
laws,
not only the laws or rules for public registry changed, but also for cadastral office. It has changed the whole system for recordation of documentation. Many years ago, the way transactions, real estate transactions were recorded was by transcribing the contract in huge books. That's many years ago, 30, 45 years ago. Later on, which is the system we are used to, incorporated actually the document as opposed to transcribe it. You just incorporate it. That's why you have to provide a copy to the public registry so that copy is there. With this change, with this new law, everything is going to become electronic. And here is where many ifs and questions are going to, arise, because there is yet no rules as to how to apply this law. The rules or reglamento should be in place on November 1st, is yet not out. Same thing had happened with anti-money laundering law. I don't remember how long it took for the rules to come in place so we could understand better. Okay. Another, now before I go there, this system now become electronic. For our industry is going to be actually very good, and Johnny is going to love it, because on one electronic archive you get to see an x-ray of the property. You don't have to go to this book and then bring me another book and another book and another book. Everything is right there. And Johnny, the description of the location and description of the property and location is right there. So when you're off, writing your offers, what is there is there. You won't have to have a problem with that.
So are they gonna electronically describe every single property that's registered down there?
Yeah, there is going to be a migration from current system to new system. It'll take a few years, okay? Probably 3 years or more, we don't know. But that law is effective, November 1st.
You mean now?
No.
So,
It's not retroactive.
Can't take one from before and get it formalized?
Yes, you can. Yes, you can. As long as you comply with the exceptions that this new law requires. If you have a private agreement signed 5 years ago, you can bring that contract to a notary and have both parties ratify signatures and content, and then you can take it to the public registry so it's recorded.
So it's retroactive when it benefits the party, the law.
Technically no, practically we can. Yes.
So we could do this tomorrow and see how it works, right, on something new?
Technically speaking, yes, ma'am.
You go first.
I don't know.
and the notary is the only one that can do the ratification?
It's the notary public who can ratify that. And please, remember me to go back to the notary. This is a problem, actually. Municipal authorities, they're registered at the public registry. any of those, or a corredor público, any of those have faculties to certify that.
So you can take the seller and the buyer with the private to the public registry, and the register there would be able to ratify the
Yes.
signatures. Like they have to take their passports and their all that.
Yes, there are certain
FMM and-
requirements.
Yeah,
that
all of that.
it's needed. Yes. What matters, and my intention in this today is let you know what is happening. I am not exactly knowledgeable as to how it's going to happen. You know, we're going to have to go through that every day with Renee and the public registry. I'm not sure if they even know completely how it's going to work because there are no rules
So we
yet.
can't show up with the buyer and seller yet.
Well,
And the
technically you
contract.
can.
I mean, we
Now,
can.
I said, please remember me, there is a problem, and for those who have been in the industry for many years, may recall that in the past, you know, private agreements was, you know, possible because notary were actually ratifying and taking signatures. It was not a problem. It became a problem when the law denied them with the faculty to ratify purchase agreements unless they were collecting the taxes right there. Remember that part? That has not changed in the law for the notary publics. So this law is in conflict with the current law. So evidently we have to expect a change of the law for the notary publics soon.
Ricardo, is this mainly for the acknowledgement and the recording of the contract itself, or does it affect establishing the base of the peso at the time that it's done, or is it only about the contract itself?
The law many times stresses that it's for legal certainty, so it's for the contract. The legislators want the world to know who is actually right now the owner. Even though it's in a private agreement, doesn't matter. Problem is, before the 1st of November, nobody could know that, except the signing parties in that private agreement.
But that didn't answer my question.
Huh?
What I'm saying is, you're now saying, so let's say we do it tomorrow, we know, and it's official that we know, and it's in the public registry that it's official. But does it establish the base as far as if somebody bought $100,000, the peso is at 20? Does it establish the base?
In my
of
opinion,
that
it
right
does,
now?
because that's exactly, on that day you bought, that's exactly what the exchange rate was. And that exchange rate should be accepted by IRS and any other authorities.
So then that leads my question. If somebody 5 years ago, when it was, or 20 years ago, when it was at 10, goes and ratifies it now is the first time when it is showing that date. Does it now accept the new base?
Yeah.
Yeah. I like that.
You can always prove that when you bought that property, the dollar and the peso exchange rate was XYZ back then.
Correct.
It's back then. It won't, you know, go to the future, and then because you paid it back then 100,000, it's gonna be 100,000 times 20 today. No. Yeah, sorry, capital gains are still there.
Okay, now on your contract, you used to have them ratified by the notary.
In my contract, what I did, I always certified a copy. It was a certified copy,
Yeah.
but it was not a ratification of the signatures. The purpose of that was to provide the contract with a certain date if I had to go to court,
Right.
okay? Because if there is no certification, the federal court says, yes, it's been dated by the parties, but it could have been manipulated. Yet, if a notary public certified this copy on such and such date, I'll take that date as valid.
So essentially now the notarios will have to be present at a closing.
Not necessarily. You can close on your office, and then you could take later on both parties to ratify. Yes.
Why later?
No, of course, why later, but not necessarily. That's what I meant.
But you're still gonna need the visa to sign before the notario and do all that the same.
The notary is going to require a valid ID, and of course, he is going to require the FMM or residency card. Yes. Yes.
There is like taxes or extra fee that you have to pay, like 2%. Of course, you know you have to pay for registration.
Not when performing private agreement. At least that is yet not been established in the cadastral part of the law. So we don't have that as a certain. But meanwhile, there is no form provided by the notary in the when he does it or she does it on a public document. No need of paying it. It's going to become another problem. See ya.
Is this only for private contracts that are being used as a finance tool?
No. No. One of the very good things this law provides now is that Rene or whoever substitutes him on the public registry is not going to be able to deny documents to be recorded unless what is specifically set in the law. There are a few exceptions. If none of those are in the documents you're presented, it has to be recorded. I don't know you, but I have seen many documents, coming back from public registry because it lacks this, because any, number of reasons. Now it's become restricted. Only that which is expressly stated in the law is what can be used as a reason to deny registry. So the idea is to give rapidness to the process as well.
But the
Yes, ma'am.
registry isn't ready for this.
I'm afraid he's yet not ready.
The notary.
As it pertains to LLCs, if they sign it the first time with an LLC and now it's sold with a new member, does that need to then be ratified again with the new member?
I don't think so, because the change is happening within the LLC only, and nothing is being affected. The contract is not being modified.
It's
Like,
still the LLC.
yes.
And it's just a bank note, well, it's not even a bank yet, because it's not.
I don't see any difference between the private and the public document. Right? See,
If this is getting recorded, could that not potentially trigger the 2% transfer tax?
Absolutely.
it should.
The city will now know.
It should. That's why I'm telling you, it will bring any number of repercussions that have not been foreseen, perhaps.
I guess the other repercussion that I'm just thinking of, if I'm representing a seller in a situation like that, and now this property is being, rectified or ratified at public registry.
Ratified, yes.
I'm the seller, Doug here is the buyer. He gets himself in hot water and someone comes after him for funds, and a lien gets put on the property under Doug's name. Right? So now I'm the seller, I got a lien on my property, I foreclose them out, but I got to clear the lien on it.
The
It's a two-edged sword.
no, but I mean the strength of this is that if you actually, it's for buyers, the most
It's
part
for
of
buyers,
it.
yeah, it's not for the sellers.
If
Yeah.
you,
That's why the seller wanted a private contract to keep himself free and clear of everything. They didn't go into a warranty. They didn't want to it's an easier
Yeah.
read one.
yeah, that may pose a problem for the seller. But this is mainly good for buyers.
Yeah.
Yes.
Is this only for new contracts, or
No.
you can record 20 years contracts that you cannot even find the owner because he passed away, it has many
And
problems,
ratify.
you still can register yourself as a buyer.
The problem is with that is that you do have to bring both parties before the notary to ratify. So if one of the parties passed away, it's not the end of the world, but it's an obstacle. You have to go probate, have someone of the state representing the state ratifying that agreement. Yes.
It says in here that the application for such preventative notice may be filed on the date of the notarial application. And it says it shall bear no cost for the applicant. Is that true?
It's not me, it's right here.
What the notarial is gonna do it for free?
No. The notarial- Yeah, right. No. These are meant for the public registry fees.
Has no
But they have a fee for that notice. That notice exists.
Huh?
We used to use it.
Preventive notice? Absolutely. I don't know why that, didn't continue happening. It's,
Nothing, a cost.
but now, by the way, now that you bring up that topic, now it's obligation. It's mandatory for notary to send a preventive notice. Prior, it was optional. Nowadays, you have to.
Are we still gonna have notarios that are gonna say they don't wanna do a public contract? Even though this,
I believe we're gonna have plenty of notarios not doing anything because their law, says you can't. You see, Article 26 of the law for notaries reads, the notary cannot authorize any act unless it's done by having it recorded in his protocol. Every bank trust that you go and do with a notary, the document the clients actually sign is kept in the notary's protocol, in the notary's archive. What you get to see is a reproduction of that contract. Actually, go check, and the last page of that contract, there is no signatures. It's just the public faith of the notary saying, before me, such and such and such and such, signed. That notary always keeps in her archives the original. That's what this article is referring to. So if any of the acts brought to the notary are not kept in his protocol, he cannot authorize, except, it says here, certified copies, acknowledgement of signatures or fingerprints, and ratifications of the content of documents. So that is possible, except when the law requires that act to be in a public document, which is the case for bank trust. So when you bring an assignment of rights or bank trust in a private agreement to a notary for ratification, be prepared.
That was Article 26 of what law?
Notarios law in Sonora. Yes.
So this new process is only for private agreements in which a bank trust is involved, or any private agreement?
No, any private agreement, but these two articles that I brought up are meant for bank trusts. Okay?
Where can we get define the complete law?
You can go to the Congress webpage. There is a link that says laws. You go there and you, on the buscador, just put ley catastral and it's going to bring it up. It's going to bring it up also with the rationale of the law. There's another provision here, Article 157. It says, who has it in English? So you have it here? Let me read it in English so I don't have to be translating what I read. When in connection to judicial acts by which trust rights in the restricted zone derived from real estate bank trusts are being created or transferred, according to the corresponding law, said rights may be subject to preventive notice. Big change. Not only we are going to be able to record those private agreements, we're also going to be able to send out to public registry a preventive notice, like if it was a public document. So preventive notice recorded in the real estate folio related to those properties, even when such acts exist on private documents. Which such acts? The incorporation of a bank trust or the assignment of rights of a bank trust. Provided the content and the signatures of such private document are ratified by the acting parties before a notary public. So if that private agreement has not been ratified, both signatures and content, before a notary, no preventive notice will be issued. And who issues that preventive notice? The notary, even though it's a private agreement. So if you're with me, Suzette or whoever else, we won't be able to issue preventive notice. Don't ask for them. We're gonna take that document, and after complying with this set of rules, then the notary will be able to send out that preventive notice. Yes?
What is the time frame for that preventive notice?
1 year.
1 year? And what happens if they haven't done that in 1 year? What happens after that?
Then it's gone. It's gone. That's a very important question, because if you do have a contract that in which you actually recorded the preventive notice but never the contract, the preventive notice is gone. That means that, let's say today we close on a private agreement, okay? And tomorrow the notary public sent and recorded the preventive notice. Right there you have a legal circumstance that is called prelación. That the fact that the preventive notice got admitted in the public registry, they keep the date and the time in which that preventive notice got recorded. And it will prevent your transaction from any other problems coming in later on, like liens. It will prevent to have them recorded. It will not prevent any creditor to actually, be on the line waiting for that preventive notice to go away. So if a year later that preventive notice expires, the first person waiting on the line becomes the accepted party, on the property, whether with a lien or something else.
So with this new article, the bridge contract that we were talking about before, will be a good idea of closing them?
Yes, that's why I said at the beginning, this law brings more basis or makes the private agreement stronger as a tool of
The
for sales.
question on that, I wanna just congratulate you because
Thank you.
I know that I've been there talking, for you being there with a new law talking like that, and the people here is very, for
Thank
me,
you.
I admire.
Thank you. I
Yeah.
apologize because I don't have all the answers, but
And just because, so there will be a lot of questions coming.
oh,
So, for example, on this one about the preventive notice for the transactions with bank trust, I think my first question, and I know the question of the clients will be, do we need to have the signatures of the buyer and the seller and the fiduciary as well on the contract? So,
Yes.
there is another
issue that we need to just to be also following with the fiduciaries. When are they going to be applying this
Part
law?
of the contract.
Yes.
Yes. So far, the private agreements are performed without having the banks signing or involved in the transaction. It's just the seller and the buyer.
Yeah, because they have nobody notifies.
Right.
Yes.
So,
But in this case, we will need to have the fiduciary signing the private agreement in order to be able to
I believe so,
present.
because the trustee is part of the trust.
Uh-huh.
Yes.
Oh, well,
Yeah. Yes.
Can you, the attorney or the coordinator do this on behalf of the two parties, or do they need to physically do it in front of the?
Unless I or any other closing coordinator have power of attorney, you can't.
They have to do it.
But if you have a power of attorney, that's different. Make sure that the POA does have in writing that authorization.
It has to be specific.
Yes, that's better.
What happened if they default?
Isabella is asking what happens if someone, the buyer defaults, or the seller, for those who be the seller, the repercussions are exactly the same on a reported document. It depends on the structure of the contract. What are the clauses? You know, if you defaulted in more than 3 consequently monthly payments, then the contract is becoming rescinded. Then it's you know what the parties agreed to. Public registry is only meant for publicity.
For what?
Publicity.
Okay.
It's not meant to constitute any sort of rights.
To be publicized and be aware of what's going on with that deal, correct?
Exactly.
Right.
That provides to the public legal certainty. If I want to go and buy condominium 500 Las Palomas, I want to know who owns it. Right now, currently, you go there and you may find the last act in the chain of title is bank trust under John Doe beneficiary. But it happens that John Doe sold that property via private agreement later on, and you have no clue that happened. John Doe may be a crook and sell that property again. Not anymore. Questions? You're tired. Okay.
All right, thank you so much, Ricardo. And, yeah.
Is there a fee structure set up here for this maintenance or recording the public?
No, it's a one-time fee. This law has been set up under a restrictive type of actions. What that means is any of the authorities at the public registry cannot do anything that is not expressly said. So if there is no rule that says that there is a maintenance fee, you know, to keep that inscription alive, there is no maintenance.
I just found out recording. The fee for the preventive notice, the fee to record the document.
There is no fee for the preventive notice. Free.
Now, remember last time that they were going to charge just 3,000 pesos per recording, and then they start charging per act. So now it's free.
Not any longer. Today is free.
Today is free.
We'll see how long that goes on.
Yes.
Yeah.
Yeah, I think that's there so you know everybody feels compelled to go and do it. Okay.
Thank you.
All right.
Sure. Okay, here. All right.
Okay, so a couple of things before we go. First of all, I want to thank all 47 of you for being here. That is, since I've become the VP of Education, that is by far the largest class that we've had.